somewhere.
Nothing exotic, no. That's pretty funny though. So let me know whenever you want me to get started. I know I was told to try to keep this quick because of the debate tonight and people who just don't want to hear me talk.
Mark, so we're ready to go. I just want to let you know that we're recording the presentation. All right.
Oh, okay. Did you just record that whole discussion about my basement?
Just turned it on, so no one else got that. But all right, so we're good to go. 39 people in the audience. So all right, go ahead, Mark, and get started.
Okay, thank you very much. Good evening, everyone. I don't know, Clancy, if you could tell me, will people be able to ask questions as we go, or how is this being handled?
At the
Up to
end.
you, Mark.
Yeah, okay, people can ask at the end if they'd like, and hopefully there won't be too much. So good evening, this is Mark Rich, Town Council from KP Law, and the purpose of tonight's meeting is to do a refresher of the open meeting law and some discussion regarding the impacts of COVID-19, the governor's order, and then give some tips and some guidelines as to how to proceed during the Zoom era. And as always, I'm very happy to answer questions and proceed in that regard. So hopefully you could also all see the screen that Clancy is sharing with the training materials. So first page is just a legal disclaimer that we always put up, just talking about how for lawyer purposes, this is not actually legal advice on specific legal matters. So this is just a general training guidance. Going to the third screen, and Clancy, are you going to, oh, there we go. Going to screen 3. So real quick overview, most of you probably are aware of this. The purpose of the open meeting law is to encourage transparency in public deliberations, eliminate secrecy, applies to deliberations of public bodies by quorum, and there are specific circumstances where even a meeting of a quorum does not constitute a meeting. We'll talk about on-site inspections where there's no deliberation, attendance at a conference or training program like tonight would not be considered a meeting for the purposes of posting on the open meeting law, and attendance by a quorum of one public body at a meeting of another public body, provided that visiting members don't act as a board. Yes? Hello? Did somebody have a question? So moving on, are you able to hear me? Kathy, was that you?
Yeah, Kathy, she wasn't on mute.
Okay. So we have we're on to screen 4, definitions. These are important. Deliberation. A meeting is a deliberation amongst a quorum of a body, a public body, and deliberations mean any kind of oral or written communication. So that could be email, it could be faxing, and in fact now it could be Facebook. Anytime that a quorum of a public body communicates, that's considered a deliberation. And a quorum obviously is the majority of the members of a public body, although there are certain circumstances where a quorum is defined differently. So usually if you have let's say a 5-member board, 3 members would constitute a quorum, 7-member board, 4 members would be a quorum. But there are circumstances where statutorily or regulatorily, such as under the Wetlands Protection Act, there are different definitions for quorum and majority. A public body is a multi-member board, committee, or commission, and it would also include subcommittees. So if a public body of 5 appoints 2 members to undertake some activity or action within the authority of that public body, those 2 members meeting together would be a subcommittee subject to the open meeting law. A single individual is not subject to the open meeting law, a town official such as the town manager or the DPW director, an individual such as that, that is not part of a public body would not be subject to the open meeting law. So if the town manager hosts a meeting of department heads, as an example, that meeting would not be subject to the open meeting law and would not be subject to posting. Moving on to the next screen. Again, I think we talked about this briefly earlier about what is and is not a meeting, but in terms of what doesn't constitute a meeting and doesn't require, it isn't considered deliberation, this is important. Distribution of materials to public body members. So you could distribute the agenda, you could distribute emails regarding scheduling or procedural information as to how to conduct the meeting. You could also distribute reports or documents that might be discussed at the meeting, as long as you don't offer opinions or ideas. So you can't send a report around and say, this report has interesting information. I think we should all read this and adopt these ideas, or I think this is a good idea. Once you comment on it, that's considered a form of deliberation. And if that is sent to all members, that could be considered deliberation and possibly be considered a violation of the open meeting law. So again, attendance at a site inspection. So if, say, the Conservation Commission goes out to look at a site, or the Board of Health goes out to look at a facility, that would not be considered a meeting for the purposes of posting on the with respect to the open meeting law. And obviously that's because you really can't post a meeting on someone's private property. There are liability issues, there are other issues. So the idea is you can go on to private property for a site visit, but you can't deliberate, you can't discuss at that meeting. If you anticipate your board wants to have a discussion in conjunction with the site visit, attend the site visit, then post a meeting after the site visit for a location where the public could attend. And at that meeting, you could discuss your opinions and findings and concerns raised at the site visit. Attendance at public or private gatherings or social events. So that again includes attendance at a training session, or attendance at a party, attendance at an inauguration, where a lot of people might be gathering for a holiday party, and they might all be on the same board or commission. As long as they're not discussing board matters, then you could all attend a party together. You could also attend a meeting of another body that has posted its meeting, as long as you're not attending as a body. If you want to deliberate and comment as a body at a meeting of another body, so let's say you have the planning board and the board of selectmen want to both meet at the same time and discuss, say, a proposed bylaw, then the both bodies would have to post their meeting. If the Board of Health wants to post a meeting and meet with the Board of Selectmen on a particular matter, both boards would have to post if they both want to discuss the matter as a board. But if an individual member of the Board of Health wants to attend, or actually I should say if all members of the Board of Health want to attend a Board of Selectmen's meeting just to hear, and if the individuals want to speak on their individual, in their individual capacity, they could do that without posting the meeting. It's just, you just have to be careful and use common sense that you're not all sitting together, talking together, and then having one person comment at the other body's meeting. Then there could be a suggestion that you are meeting without having properly posted. Slide 6. So some practical approaches. Again, if you're going to attend a meeting of another body, try to avoid an appearance that you're discussing business at that meeting. Again, site visit, post a follow-up meeting if you want to have a discussion. If you want to speak at another body's meeting, make it clear you're speaking as an individual, or post the joint meetings. Next slide. And I'm moving quickly. Obviously, if anybody feels that I'm moving too quickly, I guess you could chime in and let me know. But again, I was told to try to keep this quick, and I will try to do that. So deliberation, big issue these days. Email and text messages. There was a time when technology was not so sophisticated, but now we do have a lot of communication by email and text that could lead to these serial communications outside of a meeting. And social media also causes some problems because you could have a Facebook post and then follow-ups by members of a board or committee. If you wind up with deliberation amongst the body or even distribution among the body, you could wind up with some concerns under the open meeting law. So be very careful when you're using email. I know when I first started talking about the concerns with emails, I had one board member say, "Oh my gosh, how are we supposed to talk to each other outside of a meeting? I guess we'll start faxing each other, and that way we can talk." And I had to remind them, the idea here isn't to figure out creative ways to avoid the open meeting law. The idea here is to figure out ways to comply with the open meeting law. So don't if you think it's likely to be an issue, if you think that you're communicating in a way that's going to cause a problem under the open meeting law, just think twice and wait until you're at a posted meeting. It's just not a good idea to try to fool the open meeting law. Again, distribution of agenda or meeting materials, reports that may be discussed, that's not considered deliberation. Scheduling information, not considered deliberation, as long as you don't express opinions. You don't say, "This is a good idea," or "I think we should do this," and send along a report. That's actually a deliberation. And the Attorney General has said that even if one member sends material along with a comment to all, that's a deliberation outside of a properly posted meeting. Next slide. Again, these are practical tips to avoid violations. The reply to all button, we've all run into this. I've done it myself and come to regret it. You hit that reply to all thinking, all right, quick step to get information to people. I've done it in my own office and regretted it. So just be careful, because hitting reply to all, you could wind up replying to your full board or a quorum on a discussion, and that could result in an open meeting law violation. So if, say, your clerk or secretary has sent out materials, make sure to reply only to the clerk or secretary to avoid communication with the body. Use email only for scheduling and avoid using email to undertake town business. It's a real, obviously, for employees in the town, email is very important. For all of us, email is important, but you've got to be careful when you're on a board or committee or commission and you use email to communicate with everyone, because again, it's easy to start a discussion. I had this issue come up today in another town where it was some simple communication, but when the matter wound up at the public meeting, the discussion was very brief because essentially there had been a discussion by email previously, and now we're looking at likely an open meeting law complaint because it was very obvious that the matter that was before the board or commission had been discussed by email in advance. Don't ask for or express opinions, ideas, feelings, or beliefs in an email or the postings, Facebook as well, because that's when you're going to wind up with one of these situations where you're going to be generating a deliberation outside of a meeting. Practical stuff, a lot of it is common sense, but folks forget that when they're sending along a report and they say, "Hey, here's a good idea." Just send the report, don't editorialize, and that will help. On the next slide, we're talking again about social media. Don't direct comments to other members of a body. So if you're getting involved in social media, just don't communicate with other members. I know it's difficult, but if you see a post by one of your fellows, don't respond, don't engage in a discussion. If a matter directly involves an issue pending before a body, consider not engaging. So if there's a social media comment on a hearing that's before, say, the Zoning Board of Appeals on a variance, and you're a member of the Zoning Board of Appeals, don't jump in. I mean, it's very likely that post will be used against you, if not under the open meeting law, but even in litigation involving the decision that's being made. Be thoughtful about the manner in which comments are made. I always remind people, if you're okay seeing it on the front page of the Boston Globe, then maybe it's okay. But always be careful what you say, because it could reflect the decision-making process of a body, and that could be problematic in the future. For elected officials, separating campaign and and other accounts so that you can manage your campaign requirements and your election obligations, and not have that commingled with, say, a private email address, or especially a town email address. And remember the due process rights. So this really gets into the discussion of a matter like we talked about. If you're an adjudicatory board, if you're having a hearing on a license, or you're having a hearing on a variance, and you discuss it outside of the meeting, you may be violating someone's rights by prejudging or otherwise tainting the adjudicatory process. Notice under the open meeting law, this next slide, as we all know, 48 hours in advance excludes the weekends and legal holidays, so Saturday and Sunday are not counted. The clerk should timestamp the notice to ensure accurate record exists of the filing. If you need to amend a notice, make sure that the original notice stays posted. The amended notice, if something arises and you couldn't do the 48 hours posting, leave the original posting up, put the amended posting next to it, make a note that says amended, and highlight the item, the amended item on the agenda, and make sure the original posting stays on the board. So both of them would be timestamped so someone can see that there was a prior posting. So obviously, if you put up the new posting with the amended listing, it'll have a new timestamp, and someone can suggest that there was no posting of the meeting 48 hours in advance because the new agenda would have a different posting. You've got to file the posting with the town clerk and have it posted in a manner conspicuously visible at all hours in or near the clerk's office. That's important, especially now with so many town halls being closed, access being difficult. So it's important that these be available. There's also posting on the website allowed by notification to the Attorney General. Notice should include date, time, and place of the meeting, and a listing of the topics that the chair reasonably anticipates will be discussed at the meeting. So, sometimes we have that new business category. That new business category would cover things that might come in that were not anticipated by the chair of the meeting. And again, if the chair was not aware of those items, there are circumstances within which they could be discussed, and we'll talk about that a little bit. The topics have to have enough specificity so that someone can reasonably know what is being discussed. So I always talk about if someone at home reads this agenda and has no idea what's going on, they should be able to look at the agenda and figure out what's going on. And that can be a tricky business. And I know it's a sensitive topic, but it's something to be careful with. So always try to put more rather than less information in your agenda so that people know what you're going to be talking about. Next slide, talking about matters not reasonably anticipated by the chair. They must be added to the agenda after posting deadline to the extent feasible. So this is the updated agenda. So again, post that agenda if and this is a situation where someone actually notifies the chair in advance as opposed to somebody showing up at the meeting. So matters not reasonably anticipated by the chair can be discussed. Say somebody comes into the meeting and raises an issue, or a board member at the meeting raises an issue that wasn't anticipated, that wasn't even posted on an amended agenda. It can be taken up, but generally, the Attorney General recommends that unless the matter requires immediate action, they should be put off to a later date and included in a later posting. So I always use the example, if the town manager comes running into the selectman's office and said, we've got this $1 million grant, but it has to be signed tonight or we lose it, that's not really the time to say, well, I didn't anticipate it. That's a big deal. We're going to put it on a future agenda. You're going to lose that $1 million. So, that's a timing thing. And and we'll mention this later, timing is not necessarily an excuse for not having something on the agenda. You don't want to miss out on that. And there are mechanisms to address an issue should you fail to post an amended agenda, or fail to put it on the agenda in the first place, and you go forward with the matter. There are cures to that, and we'll talk about that in a moment. Next slide. poor planning does not equal an emergency. So if you failed to complete an item and somehow didn't plan for the meeting, that your poor planning is not an actual emergency. If the building is falling down, that's an emergency. If you just forgot to put something on and you really want it heard, that's not considered an emergency. So natural disasters and again, the issues of public safety, like if a building is collapsing and the board has to take immediate action to determine what has to be done, that's an actual emergency. And pre-COVID, emergencies really were limited to weather-related events, other circumstances. We've got a lot more emergencies now, resulting in a lot more leniency under the open meeting laws we'll talk about in a bit. If again, if an emergency comes up, comply to the extent possible, limit your deliberation to the emergency matter, take minutes at these emergency meetings. Again, if this is an emergency meeting that didn't occur with 48 hours notice, just stick to the emergency, take your minutes, include those minutes on the next meeting, and consider posting a regular meeting in addition to holding your emergency meeting that would allow the body to ratify the actions that were taken at the emergency. So you think of a situation where an emergency has occurred, the board has to meet right now, very quickly post another meeting and re-deliberate the emergency matters, because that's a mechanism to cure a defect. If you repost, re-deliberate, and re-vote these matters at a properly posted meeting, then that will cure a defect in the posting that may have arisen due to the emergency. On the next slide, so now, given the emergencies that we're under right now under COVID-19, the governor issued an executive order that relaxed a number of provisions in the open meeting law to allow public bodies to meet remotely. And as we know, there used to be a lot of limitations on remote access for public meetings. We had remote access policies. The chair would have, or the chair or whoever was acting as a chair would have to be present. You'd have to have a quorum of the body present. But now what is allowed under the governor's order is that an entire body can meet remotely. And I'm sure you all are aware of that already, that you no longer have to have anyone in person, so that we can all be at home and safe and avoid the contact. And what this requires, though, is it still requires that the public have access to the meeting. And what the order says is that the public must be allowed adequate alternative means to access a public meeting or hearing. And alternative access for the public means telephonic, internet, or satellite-enabled audio or video conferencing, or any other technology that enables the public to follow the proceedings in real time. So that means that while the meeting is ongoing, there can be live streaming of the meeting. There can be Zoom. It could be on your cable television channel through VATV. There are mechanisms to do that. You could allow people to call in and listen to the meeting if they're not able to access it over the internet for live streaming or on cable. The notice so there has to be a notice on the posting for the meeting to let people know how they can access the meeting remotely. It's very important that there be adequate notice so that anyone who wants to follow the meeting is able to. And very often, the meeting notices now will include a Zoom link that could be clicked on to allow access, or it could be copied into a browser. There's also a call-in number that can be provided so people can call in and be provided access to the meeting. There's been a lot of concern about Zoom bombing, and we've had experiences. We had one meeting not that long ago. I think it was a meeting of a planning board where someone bombed the meeting with pornographic images and really caused quite a stir. And in fact, we discussed whether those images needed to be preserved within the minutes of the meeting. And we said, certainly not. That wasn't part of the meeting. And so that did not have to be preserved as a document or a part of the meeting. But obviously, it was very disturbing. So in order to avoid Zoom bombing, some towns have required the public call in to obtain the access information rather than putting it directly in the posting. So including in the posting for the meeting a clear contact number or information where the public can obtain access. And that has to be available for the duration of the meeting, meaning that you can't say call before 10 a.m. on that day if you want to participate. If the meeting starts at 7 and it's running till midnight, from 7 to midnight, that number still has to be available. And you can't require advanced registration. I did have that circumstance in one town where they actually talked about making an appointment to attend the meeting. And of course, that's problematic, because what that does is, that essentially sets up a situation where someone has to call in advance, make an appointment, and that limits their access to the meeting. So you can have them call up. They have to be able to call up at any time before and during the meeting, and they should not be required to make a quote unquote appointment to meet. And then keep in mind also that at these meetings, all votes are to be taken by roll call. That's a requirement for remote meetings. Obviously, if the board is still meeting in public session, even if they're using a hybrid, and we have a situation where the hybrid is the board will be meeting in live format, and people are calling in by Zoom or watching by live streaming. If the board is there live, they don't have to vote by roll call, because obviously the meeting itself is not remote. The attendees are there. But if the attendees of the meeting, if the board members, committee members are all remote, or if some of them are remote, you have to do it by roll call. You have to have all votes by roll call. The next slide. As with meetings conducted in the normal course, public participation is not required. This is very important. Unless the public body allows public participation, members of the public are only allowed to view the meeting. They're not necessarily allowed to participate in the meeting. So members of the public must be able to communicate with the body and be heard by other members of the public if they're allowed to participate. So they have to be heard. The members of the body have to be heard, but the chair controls who gets to speak. A public body may choose to have only the members of the body attend the meeting in person and prohibit attendance by members of the public. That's what we were talking about a minute ago, the idea of a hybrid meeting where the 5 members of the Board of Selectmen choose to attend in person, and then they allow Zoom access or live streaming for the public. And this avoids a situation where a lot of people attempt to attend a meeting and there's not enough room to allow for social distancing, and the meeting can't proceed. Attorney General takes a position that if any member of the public are permitted to attend in person, there must be enough room for all members. This ties into the point I just made, that you can't have a situation, and this came up in another town where the members of the body said, we're going to allow 10 people to attend. We have enough room for 10 people, when that was a limitation on meetings, and after 10 people, we close the door. That's not access for the public. If you're going to allow people to attend in person, everybody who comes through that door must attend. If you don't have enough room, you will have to essentially recess the meeting to another date and time and repost the meeting. You can't continue if members of the public cannot access the meeting. So again, if you can't conduct the meeting with social distancing, postpone that meeting, recess the meeting to another time. But keep in mind that while you could recess it to another room within the same building, say you go from the selectmen's meeting room to the auditorium, you can do that on that same night to try to accommodate. But if you can't accommodate on that night at all, you're going to have to repost the meeting. You can't simply announce we're going to continue this meeting until tomorrow in order to in order to accommodate, because you have to have the 48 hours posting for a properly posted meeting. The next slide. When meetings are conducted virtually, meeting notice must provide instructions on how the public can view and participate. We've already covered that. At the start of the meeting, the chair must announce the name of the member or members who are participating remotely. This is important, that there must be an announcement of each member of the board or committee who's participating remotely, so that the public knows, and this would be recorded in the minutes. All votes taken by roll call. Members of the public body must be clearly audible to each other and members of the public at all time. We talked about earlier, if the public is given the opportunity to participate, they have to be audible as well. So make sure that your equipment is up to snuff to allow for communication by all. The other thing to keep in mind in this next slide, all of the provisions of the open meeting law continue to apply. So I actually heard from one body that said, oh no, under the new rules, we can vote by email. That's clearly not correct. Others have said we no longer have to do 48 hours notice because the open meeting law has been relaxed. That's not correct. You still have to post your meeting, and you have to conduct it in a manner that allows for that transparency in government that the open meeting law requires. It's not an excuse to toss the entire statute out. It's just a relaxation in terms of remote participation and a new process that allows people to gather remotely rather than being in person. So if the public body encounters a technical problem where the meeting is being held remotely, and the person chairing the meeting may decide how to address the technical difficulties, but it's encouraged wherever possible to suspend discussion while reasonable efforts are made with the remote participant to assure that the remote participant can hear and participate in the meeting. So if you've got a member who suddenly drops out, or if there's some technical difficulty that prevents you from continuing remotely, recess the meeting to address the communication issue. And if and that has to be noted in the minutes that you had this interruption. If ultimately you can't reestablish communication and it interferes with the meeting, that's another reason to recess the meeting. But you are supposed to be trying to assure communication and participation by the members, and the ability of the public to either participate if allowed, or at the very least to be able to observe the proceedings. The next slide. The chair is required to make a public statement regarding the audio or video recording of attendees if attendees intend to record the meeting, and that's whether you're remote or not, and that really addresses the Massachusetts wiretap statutes, which are pretty significant. So if somebody wants to record the meeting, they are supposed to ask the chair, and the chair is supposed to then announce that. The chair can't refuse it. The chair can't say, I'm not going to allow you to record it, unless the recording equipment is interfering with the meeting, and generally that's not the case. If somebody wants to put a recording device on the table, they can do that. In the COVID-19 environment, the chair can make a limited statement at the beginning of each meeting about the remote nature of the meeting, so that everyone knows that the meeting is being held remotely, and that's to address again that the meeting participants may be recording. So that should be noted. And there's usually a standard statement that acknowledges the governor's COVID-19 executive order, and that the meeting is being held remotely and being broadcast, or whatever mechanism is being used, so that the public can observe. So again, with recording, the individual is supposed to record, supposed to inform the chair. Chair is required to announce the recording, and the chair may reasonably regulate recording. So if somebody is using a camera to videotape or holding up a microphone, the chair may feel that that's disruptive or intimidating, and ask the individual to step back, place their recording device on the table, put position their camera in a corner so that it's not interfering. Luckily the days of large video cameras really have receded, but there was a time when people would try to record the meeting with a large camera, and that could block people's line of sight, or be intimidating to have the camera in someone's face. One thing that's important, and I probably should have mentioned it when we're talking about Zoom meetings and Zoom bombing and maintaining order, and this gets back to the public participation issue. Under the open meeting law, no one is entitled to speak unless the chair allows them. That's specifically stated in the open meeting law. I generally recommend that in order to maintain order and prevent the unnecessary noise, which can interfere with the meeting, and hearing children or dogs in the background, that the chair, and through their technology partners, actually mute everyone on the meeting, and then use some mechanism. It could be the hand raise function, it could be the physical raising of a hand, to allow individuals to come on as necessary to speak. Then when they are done, they would be muted. It requires a greater effort and more responsibility for the chair, because obviously this has to be done judiciously, and can't be done in essentially a vindictive manner to just shut someone off because you don't like their position. But again, the chair determines when someone should speak, and the chair can determine when someone is out of order or is speaking out of turn. And it's much easier when the chair uses that mute function, so that you don't have a lot of people speaking over each other, and have a situation where, especially where people are on the phone or other technologies, that you kind of lose track of who's speaking and who has the floor, and how to control the meeting. The other thing I generally recommend is eliminating the chat function. The chat function on Zoom can be shut off, and we've had situations where individuals have been chatting on a meeting. It can be disruptive and distracting, and it could also be confusing because people don't know if the chat messages are coming from the chair, a member of the body, or someone else who has access to the chat function. There's no need for a chat function. It's kind of like passing notes in class. The teacher doesn't like it when the notes are passed because everybody's looking at the notes and they're not paying attention to the teacher. The chair's in that same position. The chair should be able to run the meeting. The board or committee members should be able to address the public without a chat going on that could distract and could otherwise disrupt the meeting process. So those are a couple of recommendations during the Zoom era of open meeting law. On the next slide, I think we all know about executive session. You have to convene the meeting in open session first. The agenda is going to have to state with specificity why you're going into executive session. In the old days, before the current open meeting law, you used to just be able to put executive session, or even have an executive session if something just popped up. You wouldn't, because back in the old days, we didn't have to have agenda, but now we have to have an agenda. And the requirement is that you actually list an executive session items on the agenda. That item would have to list the purpose for which you're going in. If you're going in for litigation strategy or collective bargaining, or the discussion about the lease, purchase, or value of real property, or if you're going in under exemption 1 to discuss charges or complaints against an individual, or if you're going into any of the various exemptions, that should be noted on the agenda. And the agenda should include as much information as possible without undermining executive session purpose. So, again, stating all subjects that may be revealed without compromising the purpose for which the executive session was called. So if you're discussing a case that's already been filed in court, you should include the case name, the case caption, so that somebody knows what case is being considered. However, if the town is considering taking legal action and doesn't want to tip a party off, there may be a circumstance where the town would not specify who the other party is that action is going to be taken against. In general, with real estate transactions, if you're talking about a reuse of a piece of town property, you're going to probably put the listing of that property in the executive session exemption listing on the agenda. But if the town is looking into acquiring or possibly taking a piece of property for some purpose, and the Board of Selectmen want to discuss that, but they don't want to tip off the owner of that property for fear that the property value may suddenly go up, during the acquisition process, the Board of Selectmen may choose to undertake that process without listing the property. It's a careful balancing act. So again, you need to determine what can be said, what can be distributed to the public that would not disturb your executive session purpose, that wouldn't undermine that executive session purpose. To go into executive session, roll call vote. Any vote in executive session has to be undertaken by roll call. The chair would have to announce that an open session would or would not be reconvened after. Sometimes, if the executive session is at the end of the meeting, you adjourn from the executive session. Other times, you come back out of executive session. Sometimes, a contract is going to be discussed in executive session, but voted in open session, and so there's the need to come back out into open session. Stick to the matters in the executive session that were posted for the executive session. Again, take all votes by roll call. This really hasn't changed for COVID-19. It's easier now because every vote is taken by roll call. So you kind of get in the swing of the roll call votes, and you don't have to think about it for executive session separately. But don't get lazy in executive session. You stick to those roll call votes. The next slide rather. If the executive session is anticipated, again, list the detail on the meeting notice. We already talked about that. To go into executive session, include all the information, and keep in mind that there are certain circumstances such as real estate transactions or litigation strategy where the chair must determine that discussing the matter in open session would compromise the town's litigating position or negotiating position with the union, as an example. That declaration has to be made. If you are discussing collective bargaining or negotiations, you've got to list the union name as well, because obviously there is no secrecy when you're involved in union negotiations. The union knows it. The public needs to know what union you're considering negotiation strategy in regard to. So you include the union name in your executive session posting. On the next slide, meeting minutes, very clearly, I think we all know about this: date, time, and place of the meeting, the members present and the members absent. So that's why it's helpful at the beginning of the meeting to have a roll call vote of those present and record those who are absent. It's not meant to shame people in terms of them not being there. It's meant to be a record, and the law actually requires that we record those who are absent as well as those present. Detailed summary of the discussion of every topic. So you can't just say, you can't just list the matter. You have to actually list the discussion, and obviously list any decisions or actions taken. No secret ballots are allowed during these meetings. These are open meetings, so list who voted yes, who voted no, especially now that we're doing roll calls. Obviously, in the normal course, not everything requires a roll call vote, but right now you're during the COVID remote meetings, you're doing everything by roll call and recording each vote and each person and how they voted. List of documents. If you're using documents at the meeting, make sure to have a listing of any documents that were used at the meeting or that were verbally identified, and the content of these documents has to be referenced in the meeting minutes, and there's a requirement that the documents be made part of the minutes. That sometimes they're actually attached to the minutes, otherwise they're kept in a file that's accessible as part of the minutes. But keep in mind that anything used in the meeting becomes part of the minutes. And that's also important to note, because if you use at the meeting a document that might otherwise be exempt from, say, the public records law. This is an issue where there's an intersection between public record law and the open meeting law. If it's not subject to disclosure under the public records law, but you discuss it in detail at an open meeting, it becomes part of the minutes, and then it's subject to disclosure together with those minutes. So you lose that ability to claim an exemption from disclosure under the public records law if you discuss it in an open meeting. So, be careful in what you discuss. Obviously, protected health information that's protected under HIPAA, certain complaints and charges where a complainant's name might be revealed. Just be careful not to reference those documents specifically, not to hold them up and pass them around, because they'll suddenly become part of the public record, and that could be problematic under civil rights law, or could undermine other actions that are being taken by the town. The next slide, approval of minutes. There's obviously a requirement that minutes be created and approved in a timely manner. Under the current regulations, you must approve minutes within the next 3 meetings or 30 days, whichever is later. But what must be remembered is that minutes of open meetings are public records at the moment they are created, whether or not they've been approved. So if someone requests the minutes, they must be made available within 10 days. So if your clerk or secretary is taking notes, those notes are the minutes until the final minutes are approved. The notes can be destroyed once the final minutes are approved. But if there's a public records request for those draft minutes prior to the final approval of the minutes, those draft minutes must be preserved and must be provided. If the request comes in after the final minutes are approved, and that requester requests the draft minutes, those draft minutes may be gone. There's not a requirement that they be preserved after the final minutes have been approved by the body. But if the request comes in before the approval of the final minutes, then that requester is entitled to those draft minutes. They could be stamped draft, but they are still a public record. So just be mindful of that just because they're draft doesn't mean they're not discoverable through a public records request. They can be sought. And sometimes, obviously, draft minutes may have entries and information that doesn't wind up in the final minutes, but they would be subject to disclosure, and so that there should be some care in making sure that the draft minutes are taken properly. The next slide, executive session minutes approval. So executive session minutes remain in executive session, and they may be withheld until the purpose for which the exemption has been met, or unless otherwise protected under the public records law. So as an example, if you've been meeting on litigation strategy, and the case is either settled or tried to a conclusion, and appeals have been exhausted, then the minutes with respect to any strategy on the litigation of that case has been exhausted, and they may be subject to review and release publicly. However, in certain circumstances, and this happens where, let's say you're in under Exemption 1 discussing charges or complaints against an individual, there may be some personal information that's revealed during that would not be subject to disclosure. So a situation like that may never be resolved. Or you may have a situation where there are discussions that are of a personal nature, or certain union negotiations. We take the position that the strategy that you undertake for union negotiations for one union may impact the negotiations for another union, and on, and it would be detrimental to the public body if those negotiation strategies are revealed. So in that case, even though a union contract is resolved, the negotiation strategy may impact negotiations with another union, and therefore those can be withheld even though that particular union's contract has been resolved. So it's important to review each set of minutes to determine when that set of minutes is subject to being released. The law allows specifically that the chair of the public body can review the executive session minutes periodically, and then bring the minutes to the body for its approval for release. And so the executive session minutes should be reviewed in executive session. Obviously, it doesn't make sense to review executive session in open session, because then you revealed everything that was in executive session whether or not that is subject to release or not. So you go in either for the same purpose for which you originally went in. So even though you're no longer discussing litigation strategy, but you're discussing whether to release minutes that contain litigation strategy, you still go in under that same exemption 3 for litigation strategy. You could also go in under exemption 7, which references for purposes allowed under law, and that's a catch-all. But I generally recommend that you go back in for the same basis for which you went into executive session in the first place. You've got to provide a response to a request for executive session minutes within 10 calendar days. So that response would be either that those executive session minutes are going to be reviewed, or they're subject to being revealed. But again, you have to respond within 10 calendar days. And this, again, differs from the public records law, which allows you 10 business days for response. This is a response within 10 calendar days. The next slide talks about open meeting law complaints. Written complaint under the open meeting law has to be filed with the public body, not just the Attorney General, but the public body within 30 days of the alleged act of violation. So if the meeting occurred more than 30 days previous, the Attorney General will not take cognizance, and the complaint is deemed stale and not subject to consideration by the Attorney General. Public body has 14 business days to respond to the complaint and inform the Attorney General and the complainant of any remedial action or other response from the public body. So to tell the Attorney General what the body is going to do to resolve a violation, or to simply state, we don't think there was a violation. Complaint may be filed with the Attorney General 30 days from the date of the complaint was filed with the public body. So if you get the complaint within 30 days after that complaint, the complainant may bring a complaint to the Attorney General for further action and enforcement, and because the complainant may disagree with the response that came from the town. Next slide just talks about enforcement. That the Attorney General can take a number of actions, may require the public body to consider the complaint promptly. The matter must appear on the meeting notice. So this is if you get the complaint. You have to place the matter of the notice of a complaint on your agenda. You've got to acknowledge receipt of the complaint, deliberate concerning the allegations and the possible resolution, vote to resolve the complaint, or vote to authorize, generally it's town council, to respond. So when you get that complaint, within that 14-day time period, you need to schedule a meeting of your body, have that complaint on the agenda. So usually the listing is open meeting law complaint, the name of the complainant, the date of the complaint, and then review and receipt and review of complaint and referral to town council for a response. And then it comes to us and we'll work with you on developing that response. As we talked about earlier, a cure to a violation, if there's a suggestion that the matter was taken up that was not properly posted, a cure can be to now take that matter up at another properly posted meeting, to deliberate on that matter, have a full and complete deliberation, and ratify, validate, and confirm the action that was taken. So that can be a cure to your an alleged violation. And we also recommend releasing minutes as quickly as possible to demonstrate what was done and to avoid a claim of a violation. The next slide talks about what the range of options that the Attorney General can take in enforcement. Compelling compliance, attendance at a training. Very often, if we think there's a real problem, we'll indicate in our response letter that town council will be providing a training, and that sometimes satisfies a requirement. Creation or disclosure of minutes are required. Nullifying action that occurred at the meeting. The Attorney General could actually say the action taken is null and void. This is why we talk about reposting, redeliberating, ratify, validating, and confirming, so that you've properly addressed the matter and you could avoid any effort at rescission, and a $1,000 fine against the town for intentional violations. Public body may seek judicial review in Superior Court within 20 days of receipt of an order. Public body may not implement any action taken pending the appeal. The Attorney General can file an action in Superior Court to require compliance, and 3 registered voters can bring an action in Superior Court as well, although ordinarily registered voters and complainants choose to take their action through the Attorney General's office process. And then the last page just gives you the Attorney General's email address, or I should say not the email address, the website, and also links for open meeting law purposes. And finally, my name and contact information. Actually, unfortunately, I had somebody else's email address on there. I don't know how that happened. So that's my training. I think I brought it in just under the hour that was suggested. And I guess I'm open to questions if Clancy and Kathy, if there's a way for folks to now be able to jump in with questions.
Yep. So Mark, I got the first question for you. So when we post an agenda in the beginning, we were posting just a link to the website, but now we've started posting with the actual sign-on Zoom information. Do you have a preference to what we do?
If either way is acceptable. I know a lot of towns have hot links on their website, website postings, so that people can click right on there. It really depends on your technological savvy. I think whatever you could do to make access easier is better. So certainly, if you can make access easier, that's the best way to do it, and it really gets down to your technological abilities.
Sounds good. All right, the first person up, Mark, is John Gray. John Gray, you're in the meeting. Just unmute yourself. John, are you there?
Yes.
There he is.
Go for it.
I was just wondering if the telephone of the vote is some members are present and some has by remotely. Are you required to have a roll call vote?
Yes. If any members are participating by Zoom or by telephone and they're not present, you'll be doing a roll call vote.
Is there any exception outside a roll call vote?
If you're doing remote, you're doing roll call votes.
Okay.
If you're not remote, you're not. If all the members are participating live, then you don't have to do a roll call vote.
Okay, thank you.
You're welcome.
Mark, next up is Marlise Henderson. Marlise, you're in the meeting.
Great. Thank you, Clancy. And Mr. Rich, if you could help answer this question. Typically, the select board has a town manager's report on the agenda.
Yes.
And I tune in because I want to know what's being discussed. Oftentimes, they discuss interesting topics, but I wish those topics would be listed on the agenda. There's considerable discussion. These topics get discussed at length. And then usually I have to wait till it gets on BATV or something and watch it later. But it would be nice if it's also on the agenda. Is that a fair question to ask?
Well, that'd be a question again for the town manager. I'm not going to comment on whether, unfortunately, whether a town is doing something right or wrong in a training like this. But essentially, if an item is listed on the agenda and no vote is being taken, then you have a little bit more latitude. But in general, it's important that the public be aware of what the item is that's going to be discussed.
Yeah, I understand that the town manager is not subject to that law, But the Board of Selectmen or the Select Board, they do discuss, and I thought it was all about the deliberation and the discussion. But I guess I'll ask the town manager or the chair of the board.
Yes.
Okay, thank you.
Mark, next up we have Janet. Go ahead, Janet. You're in the meeting.
Okay, can you hear me now?
Yep.
Yep.
Great. I just wanted to thank you for this presentation. I think it's really a wonderful idea, and that maybe we should do this annually. This is really good. So I'm on the planning board, and one of my questions is, you had talked about, litigation and such. If we have to make a decision on a denial decision, and it could go to possible litigation, what is your recommendation on getting into executive session? Is it, because, when people are giving their opinions, we're told we're supposed to give our opinion as to if we vote something down. And then, of course, the attorneys are also listening because it's public. What's the best course for us to do that?
That's an interesting question, Janet, because for better or for worse, your deliberation on a decision must be done in open session. We get this question all the time where bodies or boards that are making quasi-adjudicatory decisions, such as the planning board, the zoning board, the Board of Selectmen acting as a licensing board, or even the Board of Health, have to make these decisions, and the deliberation kind of can give a window into areas that can be explored by crafty attorneys. And so I do recommend being very careful in your deliberation, but ultimately you cannot go into executive session to deliberate on a decision or to discuss the decision-making process. You can only go into executive session once there's a threat of litigation against the body or actual litigation. So in general, the planning board process is an open process, and the deliberation on the decisions is undertaken in open session. And you just need to be very careful how you word your deliberations.
Okay, that's great. I appreciate that. If I could ask you a few more. On open mic, it seems like we have something written in our bylaws where we allow people to have open mic at the beginning of a meeting. Does that need to be on the agenda? And can the chair put any restrictions on open mic, such as, not to talk about items that will be on the agenda later? Or is it carte blanche that people can discuss what they want for their 3 minutes?
Well, this is a controversial topic, obviously. and many towns have public comment open mic, and generally that's an opportunity for members of the public to speak, and it kind of is an opening for individuals to speak. Once you open up that forum, there is a recent case that essentially says that that's an open forum, and people can speak on whatever they want to speak on. However, the open meeting law itself specifically states that the chair determines who gets to speak and when. And so we have to read the bylaw consistent with the open meeting law. And so, again, I know this is a controversial issue, but a chair can actually set rules, can say that open mic, we're only going to allow it for 15 minutes, so that our meeting doesn't go for hours or a half an hour, whatever is reasonable. And I'm only going to allow people to speak for 2 minutes, 3 minutes. And you'd be surprised at how long 2 or 3 minutes are. I know you've been listening to me for an hour, and that must seem like an eternity. But so I do, in my opinion, I do think that the chair can set rules and limit the discussion. The recent case that interpreted this was a Superior Court case, and essentially said that in that case, it was a school committee that tried to silence some parents who were making negative comments about the school and certain teachers, and they were silenced, and they claimed that their rights were abridged, and the Superior Court agreed with the parents, and the school. So the school was told that they had to allow the school committee was told they had to allow people to speak. The case was not appealed. It was settled out of court. So we only have a Superior Court case. I have some issues with that finding, because It is not consistent with the open meeting law. So again, in my opinion, the chair does have some discretion to manage open mic so that the meeting doesn't go on forever and that comments aren't made that are considered harassment or bullying or inappropriate. Keeping in mind that once you allow people to speak, you cannot censor content-based speech. So you have to be very careful in how you decide to restrict people's speech.
Okay. Yeah, I mean, as long as we know the guidelines, I think in applying them at every meeting is fair. So
Applying them across the board, yes.
exactly. Two more quick questions. If you want to get an item on agenda, what's the best way to do it? And should we email the chair? Should we
Yes.
email? Okay.
The chair generally, and again, the agenda setting is not considered deliberation, but the chair pretty much controls the agenda. Although I know that the town has other regulations in terms of how board members can get items on the agenda. But again, given that the open meeting law says that the chair decides who gets to speak, that essentially gives the chair some authority over the agenda. But if the chair cedes that to a secretary or clerk and says, you put together the agenda, then send it to the clerk or the secretary. But if the chair manages the agenda, it's acceptable to send an agenda item directly to the chair.
And just them, not the whole board.
Believe it or not, again, agenda setting is not considered deliberation. So you could technically send it to the whole board. The problem with doing that, though, is you send an agenda item and somebody responds to all and says, I think that's a good idea and I want to do something about it. And then you've got an open meeting law violation.
Okay. Two more quick questions.
Two more,
sorry. This is a really good meeting.
Good.
Does Zoom require cameras to be on for people if that technology is there? I had a few people say, we're watching the meeting and we see some but not others. And I just want to know if we have to be consistent.
No, I mean, Zoom, the regulation requires that there be adequate alternative access. And so if some people don't have cameras available to them, I mean, I'm looking at the screen right now, I can't see any faces. And so if this was and again, this is a training session, so it's not subject to the open meeting law, but if it was, as long as individuals can follow along and so they could be heard and understood, then not everybody has to have their camera visible. But again, you have to announce who's on the meeting so that people could identify. So at the beginning of the meeting, whether they're visible or not, their names would have to be called.
Okay. And finally, my last question. Is the word agenda and notice interchangeable? I thought they were two different things.
They're technically two different things. Under the old open meeting law, notice was all that was required. Now the notice has to include the agenda. So if you think of them as intersecting circles, the agenda fits inside the notice.
Perfect. Thank you so much. Those are my questions.
You're welcome. Thank you.
Mark, next up we have John Curran.
Mr. Curran, how are you?
John, you're in the meeting.
How are you? Just two comments. One, I know Marlise had mentioned about town managers' reports. Generally, I don't put anything on the report that requires any action, so just to make sure that we don't get into trouble that way. So if something requires action, it shows up as an agenda item, not inside the report. The report is basically a summary of things that are going on in the town, and to put that on the agenda would sometimes it could make it a 4 or 5 page agenda of word salad. So we generally don't put that on. I do try to post the managers' reports on my web page, so you can see them there. I think I'm behind a few weeks, but I'll update those. But I wanted to make sure that I responded to that. And then just as an just as a point of information, this meeting, we put this meeting together in response basically to there was some concern about some behavior at a meeting where somebody was muted, and I know you talked about that, Mark. And there was an OML complaint filed about that, and the AG found that there was no violation in the behavior at that meeting. So I just wanted to just make note of that, only because I was asked by several people that I should take disciplinary action against an employee. And just for people's information, that person was not my appointment to that committee. So that person was in that position by virtue of a bylaw. So I don't have a lot of control over that. And but I just wanted people to understand what the action I took was to put this together to help people better understand how open meeting law works, and now unfortunately how it works in the era of COVID. So hopefully that is an adequate and appropriate way to address the concerns that were brought up. But I just wanted to clarify that. Thank you.
Thank you, John. I didn't want to raise specific instances, but obviously we were pleased to get that result, and it was consistent with the advice that I had given and the advice that I gave tonight. And again, it's a recognition that it's very complicated to run a meeting in this fashion. It's easy when you're sitting before a body and you're sitting before an audience, and the chair can manage by telling people to sit down and stop speaking. And in fact, as we know, at an open meeting, the chair can have someone removed. And effectively, the way things are controlled now to keep order in a meeting, and you look at the meeting we've got right now, I think everybody is muted until Clancy brings you on board. That avoids cross chatter, it avoids noise, but it also allows for management of the meeting, and the chair controls that. And yes, thank you, John. The decision confirmed the ability of the chair to do that, and certainly no disciplinary action would have been necessary or appropriate.
Mark, next up we have Bob. Bob, you're in the meeting.
Hi, Attorney Rich, how are you?
Good, how are you?
All right, Bob Accomando here from the Zoning Board of Appeals. First of all, I'd like to say this was very, very informative. I enjoyed it. You brought it down to a level where everybody can seem to understand it.
Great, thank you.
And just one question, which unfortunately John Curran beat me to this question. My question was, you have someone talking for an extended period of time. You have somebody else that wants to talk. So you mute the first person, they had their shot. You go to the second person. Well, we got a complaint saying that the first person shouldn't have been muted. They should have been able to carry on. And what I'm trying to figure out is, how can you have a controlled meeting if you just said it? If everybody's open, you're going to have cross-talking, you're going to have, so I agree wholeheartedly, and I'm glad you brought it forward, is that it's like telling someone to sit down and be quiet at town meeting.
I don't mean to think of people as children in a classroom, but in some meetings that I've been to, it gets to that level, and I'm not trying to impugn anyone, but I think that the purpose of the open meeting law is to allow access to meetings, but it's also designed so that the chair can maintain some level of control. And if we have everybody able to jump in, imagine if everybody on this call was unmuted, and there'd be no way to control the discussion. And especially in these meetings, it's almost impossible to determine when someone has spoken long enough. I certainly think that it's polite to let someone know, all right, you've spoken a long time. We've got a lot of people online, and we need to move on, and give someone a warning. But at the end of the day, the chair has discretion in how to address the meeting, as long as that discretion is carried out in a lawful manner. So it can't just be, I don't like what you're saying, so I'm shutting you down. It's more, you've spoken a long time, and it could be you're off topic. You're no longer in order, and the chair can rule someone out of order, just like the moderator does at town meeting. And town meeting is not subject to the open meeting law, but the chair has the same authority as a moderator. You're out of order. I'm asking you to stop. If you don't stop, I'm going to cut you off and mute you. And it's pretty effective. And it's one thing that's actually very effective with these Zoom meetings is you could actually really shut someone off.
Yeah, I think that I always thought it was a good tool. You know, so if you've got someone who's been rambling and now they're rambling about something else, you can mute them and give the other 10 people waiting to talk a chance to talk.
Just be careful with it. Obviously, like I said, don't use it in a combative or punitive manner. Give someone a warning and say, look, you've gotten off topic. I'm going to, if you continue, I'm going to shut you off. And, that's acceptable. And that was the decision we received from the Attorney General.
Excellent. Well, thank you for your time. And then once again, I really enjoyed it.
Thank you. Thank you.
Mark, Kim's up next. Kim, you're in the meeting.
Hey, Mark.
Hi, Kim. How are you?
Good, thank you. I have a quick question. I was actually going to ask the same one Janet did about whether or not the cameras had to be on. So thank you for answering that. But a lot of elected officials and appointed officials will post the agendas on social media today, and sometimes they'll ask for residents' comments. You know, what do you think? This is what we're going to be discussing. And I think if I understood you correctly, it's okay to do that, and it's okay for residents to comment on it, but it's not okay for other board members to comment and debate on it. Is that how we interpret that?
Yeah, it's a great double-edged sword, isn't it? And it can lead to problems. And I'm personally not a big fan of social media because of all the traps for the unwary. But no, it's absolutely fine. The idea of an agenda is to allow the public to think about an item and consider it, and then inform themselves so they go into a meeting and understand it. And it's certainly useful. It's a useful tool for social media or other exercises to get constituents' opinions and members of the public to say, I think this, I think that. And that would inform the discussion before, say, in your case, the Board of Selectmen, which, is a policy-making body, to hear from all the residents of the town and then bring those concepts to your meeting. The problem you get into is if you hear from a resident and you respond and all of your fellow members are part of whatever Facebook group it is or otherwise join in, that's when you run into the possibility of a violation. So hearing from and taking in the comments from the residents, that's fine. Putting out your own opinions, and obviously you're elected officials, you're elected to have opinions and to represent your constituents, but you should make those opinions known at meetings and be very careful that if you're sending them out through social media, you run the risk that more than one person on a board can be communicating, and suddenly you have a possible violation that we'd have to address.
And so just for clarity, Mark, if we post an agenda on social media and we don't engage in debate, just say, here's the meeting for Monday night, and I would love to hear your thoughts or something, but don't comment any further on it. Is that okay?
Yeah, I mean, the point that's made by the Attorney General is if you comment on something, that's deliberation. But if you ask for comment from the public, that's not deliberation. The public is not subject to the open meeting law.
Okay.
They can talk as much as they want.
Okay, great. Thanks, Mark.
Mark, next up we have Taryn Gillis. Taryn, you're in the meeting.
Hi, Mark.
Hi,
I'm
Taryn.
Taryn. I'm a new Billerica representative to the Shawshene School Committee. And my question is, if there's something on the agenda that is stated as an update, and then it becomes and so there's discussion, it's on the agenda, but then there ends up being a vote regarding what we discussed. Is that a violation of open meeting law to have a vote over something that was only listed as an update? And if you already covered this, I apologize. I had to step away for a few minutes.
No, that's a good question, Taryn, and it's a tricky one because we take the position that if something is on the agenda and it's clearly stated, that it could be anticipated that there may be a vote on it. I do encourage that if there's an item that is subject to vote, that the agenda items can simply say votes may be taken, but there have been decisions made where a vote is implied by the fact that you're deliberating on an item. So it really depends on how the item is stated. You know, I know we've had this discussion where an agenda said, you know, review of the warrant, and then votes were taken on the warrant, and there was a concern about whether the implication was that that review would include votes on specific items. So in general, I do recommend that the language "votes may be taken" be added to the agenda if there are items that are coming up that it wouldn't be clear that they were subject to a vote. And I've also taken the position that if there and I think the town manager talked about this with his reports. If you have a general report that appears on the agenda and there's a discussion of the report, and within the report there are action items, things that should be voted, it's a good idea to call those out separately and list them for vote. If it's not clear on the agenda, it's a good idea to put off the vote until the next meeting so that it can be posted. Because sometimes things come up that in the update or the agenda or the consideration of report, someone says, "Oh, we should vote on that." Put it on the next agenda, or if you do vote it at this meeting, put it on the next meeting as well to ratify, validate, and confirm the vote so that it's properly posted and redeliberated.
Okay, thank you very much.
You're welcome.
Mark, next up is Marlies again. Marlies, you're in the meeting.
Yeah, thank you, Clancy. And Mr. Rich, just to get back to the topic you talked about, thank you very much for pointing out that the chair must warn that the member will be muted if the member continues to speak. I thought that was important, and the Attorney General also has stated that they strongly discourage using technology to silence members engaging in civil discourse regarding committee business. I just thought to put it out there to keep everything straight. But yeah, I think your presentation today was very good, as always. I've attended many, and I hope many board and committee members watched it. And I think it was educational, but yeah, I've heard it before. Thank you. Very good.
Mark, next up is Darlene Torrey. Go ahead, Darlene.
Hi, Mark. Thank you for hosting this. It was very informative. You had mentioned about participation at meetings. So one of our policies, BEDH Section 5, says no individual during his or her public comment will be permitted to attack town employees or elected or appointed members of the committee, or to make a comment on any matter not within the purview of the school department. So are you saying that we should be changing that?
No. What I'm saying is that it's kind of an untested area, and that's what was interesting in the Natick School Committee case that I was referencing. Is that there were parents who came in and actually attacked the school department and two teachers, and the school committee silenced them, and the Superior Court found that once the forum had been opened, once you allowed public forum, you had to take the bad with the good. And I know that many towns have specific policies that say personalities and personal attacks will not be tolerated. And you could almost look at it as an anti-bullying opportunity where you want to keep discourse civil, and the idea is to have public comment and not the opportunity to attack an individual, to say, come into a school committee meeting and say, my child has teacher X and teacher X is terrible and I'll tell you why. And and that's usually found to be out of order, because teacher X didn't have any warning, no notice, and we have a very specific process to handle that. I'm pointing out that case, but again, as I said earlier, that was a Superior Court case, and one that I take issue with. I'm sorry that the school committee settled that case rather than appealing it, because I would have been very curious to see. Superior Court cases are instructive and informative, but they're not precedent. Your precedent comes at the appeals court and Supreme Judicial Court level. So I look at those cases out of interest, but I'm bound by a decision, and I base my opinions on a decision of the Supreme Judicial Court and even the appeals court. And we don't have a specific decision here. So there is a kind of a split between the open meeting law itself and that decision. I think that under the open meeting law, the chair can determine, set kind of rules, and if the chair is upholding the rules of the committee, then those are the rules of the participation. And there is no requirement under the open meeting law to even have public participation. The public is entitled to view and observe, but not necessarily participate. This is not talking about public hearings. Obviously, public hearing is very different, and that's not governed by the open meeting law. And in fact, the Attorney General will not comment on issues about public hearings because they're not part of the open meeting law. But so no, I'm not telling you what you are doing is wrong. In fact, most public bodies do that. What I'm saying is you need to be careful, because one of the issues that came up is if someone comes in and says teacher X was terrific, I love teacher X, we all love that person, are you now censoring somebody who's saying teacher X is terrible? I think you just use your discretion, but I think bullying and negative comments about individuals really sets a poor tone for public meetings. And until there's a precedential decision otherwise, I do support the authority of the chair to properly restrict access at a public meeting.
Okay. Yeah, I mean, we had that issue last year, and I tried to guide the person speaking, to, hey, we don't do that, but let them speak, but kind of not censor them. But like I said, guide them to what we allow and not allow, because the teacher wasn't there. She had,
Right.
like you said, no notice to be there to defend herself. And there's no saying that what this person is even saying is the truth.
Well, as you probably know, there's no rule that says you have to speak the truth at a public meeting.
Right. Yeah, exactly.
But at the same time, it's not a face your accuser situation. I'm not saying
Right.
you can only speak if the person you're accusing is standing right there. But I think that you have kind of a responsibility to manage the discourse, and I think this has been discussed by a lot of the school committees. When I gave a training at another town where the school superintendent was in attendance, that superintendent brought up this native case also. I know that it's something that's been hotly discussed among school committees, because this is an issue with teachers and attacks on teachers, and obviously the school committee, as trying to be informative to everyone in the school community is trying to teach anti-bullying, and that's something that we all need to be mindful of. These are not opportunities. Public comment is not an opportunity to beat someone up publicly, and I certainly would never say you can't use the opportunity to guide, as you cleverly said, guide the person in how best to communicate. Obviously, when you have an open mic, people are going to speak, and you have to be careful that you're not using content-based censorship. But what you're getting into is more, the bullying aspects, and I think that has to be properly addressed.
Yeah, I'm glad that you brought up the point about muting too. And I agree, legally, you're supposed to give a warning before you mute somebody. But I can say, as a former chair, I hold myself to a higher standard, and to just mute somebody, you need to do it respectfully.
I agree with that.
All right, thank you. Great seminar.
You're welcome.
Appreciate it.
Thank you.
Mark, it seems like we have our last person. I'm going to put them in their meeting. It's Dawn. Dawn, you're in the meeting.
Good evening, Mark. Can you hear me?
Yes, I can, Don.
Great,
Thank you.
great. Thank you. I got an easy one. We'll finish this off with an easy one. So, in a case where you have a request for the minutes of a meeting and the minutes are not final, in the day of Zoom, can that be considered if you give them the Zoom meeting as a draft?
You mean if the recording of the meeting?
Correct. Would that be sufficient?
Yeah. If you have, and that's not even in the non-Zoom context. A lot of times a secretary is taping the meeting, and the tape is what is the rough draft, and the minutes are derived from the tape.
Right.
If someone makes a request and the only form of minutes is a tape or a recording, then yeah, you could certainly provide that, because obviously a recording is the full meeting. So yeah, that would be acceptable. Obviously, ultimately, the minutes have to be generated, and in fact, once the minutes are generated, the tape or the recording can be destroyed. But unless the recording is being used because of for some reason the meeting could not be otherwise adequately provided to the public. But in terms of the minutes, yeah, that's a perfectly acceptable alternative.
Great. That's what I wanted. Thank you.
Sure thing.
Last chance if anybody has any final questions.
Got half an hour to the debate.
Mark, I'd say you're good. Good job. And you got anything else? I
just, again, wish everybody luck in managing these meetings during these trying times. It is a challenge, and I have the utmost respect for all the boards and committees in trying to navigate through these difficult times.
Awesome. All right. All set. Thank you, Mark.
Great. Thank you all. It was great to see you, or talk to you, I should say.